I hear that a lot. Either a client will be discussing a claim directly with customer care, or even worse, with customer care through the dealership. I've had clients say to me, well, the dealership told me that the manufacturer told them that they're not going to buy the car back and they're not going to do anything, when in reality, we're dealing with a legal department. We have a completely different claim going. The dealership knows nothing about it. Customer care knows nothing about it. And yeah, Emma, you're exactly right. Clients will often get frustrated thinking that we're doing nothing or nothing's going on with our claim. But like you said, in reality, they're two completely different offices over there, and they do not talk to one another.
Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Steven.
And today we're going to be talking about common manufacturer loopholes or delay tactics they may use to make you think that you don't have a lemon law claim or try to avoid liability when you're having issues with your car. I think that where we can start is the most common issue that we hear from consumers is the lack of effectiveness of customer care, right? They call in, they get a case number, they get assigned a representative, but then nothing really happens from there, right? It's a lot of lip service that we hear from clients that can cause them to delay in seeking the advice of an attorney or starting a lemon law claim because they think that they're getting somewhere with them, or they think that if the communication ceases, that everything's going to end for them and they're not going to have any recourse, right? I think that's like the most common complaint that we hear, that usually once that gets to be too much, the client usually reaches out and gets representation.
Yeah, I hear that from clients all the time, that they have a case number and they have a representative assigned. So, they thought it was going somewhere. Or they thought there was going to be some sort of resolution. And unfortunately, having a rep assigned and a case number really doesn't mean much of anything. A lot of times they will kind of just string you along and never make you an offer or make you a very small offer. So if you're not getting an adequate resolution or a timely and efficient resolution through customer care, never hesitate to reach out, because we can always file a claim, or another attorney can file a claim simultaneously, and it will kind of supersede that customer care that you have going on, and we can often get responses a whole lot quicker.
Also, it can be really frustrating when you reach out to customer service. It seems like things are moving along. I got a case number. I'm talking to someone. But all of a sudden, they switch. They play musical chairs with who is handling your case. Oh, you've been assigned a new case manager. Oh, you've been assigned a new case manager. At a certain point, clients are saying, well, I'm not sure who I'm talking to because I've had 5 different people assigned to my case. It's not going anywhere. Is it really even being reviewed? This is just one of the tactics just to string it along and say, oh, well, you know what? This person's no longer on it, but I'm going to review it now. And then it'll be another 3 weeks, another 4 weeks, another 5 weeks. Then a new case manager comes on. You kind of almost start over again. And they make you think, oh, well, we're helping you. But realistically, they're just dragging it on, just hoping that you get discouraged at this point.
Yeah. And I've had it before, too, where clients get frustrated because all they're leaving is voicemails, right? They're constantly calling the customer care rep that's assigned to their case, and they just never pick up the phone. So they feel like they're kind of at a dead end. But I've had it before, too. I had this case out of Illinois where our client was in touch with customer care, right? And then we took over the claim and we were in touch with a different division, right? And so customer care, as I like to say, sometimes the right hand doesn't know what the left hand's doing. So customer care is giving the client all sorts of misinformation. We had the buyback, right? We had the repurchase. We had the offer. We were just waiting for the surrender. It was taking a little bit longer than the client would like. So the client was calling customer care. Customer care is like, we don't have a buyback for you. I don't see anything in this system. And of course, then they get frustrated and start yelling at us when really it's just a matter of we're not dealing with that group, right? That's not their legal group. That's the group that deals with consumers that call in for problems. We're dealing with an entirely different section of that manufacturer. And we have the repurchase offer, right? I can send it to you in writing. We do have it. And by you communicating with customer care, if anything, you're just causing delays, right? And causing stalling. And it ended up actually causing a lot of friction in our relationship between me and the client because they just kept relying on this random customer care representative who knew very little about the case, telling them that nothing was being done when it was actually quite to the contrary.
I hear that a lot. Either a client will be discussing a claim directly with customer care, or even worse, with customer care through the dealership. I've had clients say to me, well, the dealership told me that the manufacturer told them that they're not going to buy the car back and they're not going to do anything, when in reality, we're dealing with a legal department. We have a completely different claim going. The dealership knows nothing about it. Customer care knows nothing about it. And yeah, Emma, you're exactly right. Clients will often get frustrated thinking that we're doing nothing or nothing's going on with our claim. But like you said, in reality, they're two completely different offices over there, and they do not talk to one another.
Yeah, it's two separate groups. I mean, I have other examples I could give too of sort of the same thing happening, right? Or where we have the client calling the customer care representative repeatedly, and then customer care is reaching out to us saying, please have your client stop calling us, right? They're represented by counsel. We can't talk to them directly, which some clients understand that, right? They look at it and they're like, okay, I get it. I'm represented by an attorney. So are they. So they need to talk. But we've had other clients too that are like, well, I don't understand. If I want to talk to them, why can't I? There's nothing saying that I can't communicate directly with, GMC, for example, to talk about my case. But what they don't understand is that's all voluntary, right? So the ABA rules basically say when two parties are represented by counsel, the two parties themselves can talk to each other if they want, right? As an attorney, I can't talk to that attorney's client directly, right? I have to talk through their attorney. But if the two parties themselves wish to communicate, they can. But if one of those parties does not wish to communicate and wants all communication to go through counsel, they have the right to invoke that privilege and say, hey, I don't want to talk to you. I want everything to go through my attorney. And really, that's just usually safeguarding, right? To make sure that everything is streamlined, all the communication is clear. But we do have some clients that get upset by that, kind of seeing it as more of preventing them from being able to accomplish something, or the attorney stepping in and causing, gatekeeping, as opposed to them just saying, hey, listen, this is my choice and I'm choosing to exercise it.
It's amazing how often this subject comes up. It's easily almost not, if not every other day, for sure every week that I have at least one client who wants to talk directly to who I'm dealing with on the other side for the manufacturer. I literally had a case last week where I was saying, well, your counter demand is being reviewed. And they're like, well, can we just have a conference call? Let me talk to him, tell him my story. I'm like, they're not going to do that, unfortunately. You're now represented by us. And at this point, they want to keep the channel clear and just communicate directly with us, but they're not going to have a conference call with you and the supervisor on this matter. Fortunately, it did get resolved, but at the time I had to try to explain, they don't really want to hear your side of the story. They want to try to get this resolved as quickly and successfully for both sides as possible in some situations.
Yeah, clients do often think, and it's not a bad thing. I mean, they're not wrong in wanting to express their side and express their story, because I don't disagree that the repair orders don't always tell the full details, right? But they do give a little bit of too much credit to customer care and to the representatives at these manufacturers. I don't think they sometimes realize the volume of cases they have, right? And the volume of matters that they have in front of them. And unfortunately, you're not the top of their list. They're not going to spend a half an hour of their day listening to you, letting you talk, or do, or especially with their supervisor when they have hundreds of cases to be reviewing. It's just a different ball game when you're at this level versus customer care, right? What we're talking about is when we're dealing with their arbitration group or the group that deals directly with the attorneys. Customer care, their 1-800 line is different. You want to call and chat with them, that's sort of their responsibility. But when it comes to these higher levels, their role is to review the case and try to come to a resolution. It's not as in-depth or involved as, unfortunately, like our clients may think it is. And the same is true for court, right? We've kind of said the same thing when it comes to judges and juries, that it's not always this thing where if you can just get up and tell your truth, that everybody's going to hear you, which, is kind of a tough conversation to have without seeming callous, right, to what they're going through.
Yeah, it's unfortunately very black and white. It can be rather cold. What matters is the repair invoices, the dates on the repair invoices, and what repairs were done, and not any of this extraneous information that might have been and is a big deal to most people and most of our clients. I had a gentleman yesterday say to me, we couldn't take my vehicle because it was at the dealership. I had a loaner, but it was too small to take on vacation. So we had to take my wife's lease on vacation, which made us have to put more miles on her lease, which we're going to have to pay for at the end. And it's all of these things that it's an important thing to a consumer, to an individual person. But unfortunately, under the law, it doesn't come into play. It's so much more black and white and streamlined than all of those extraneous details.
Often I have clients say, well, here's my whole story, and they'll send me an email, and it's very important. I completely understand the situation that they're in, but the easiest way to break it down is we're looking at the car itself, unfortunately, in these situations. What is going on specifically with the vehicle? While the human factor is important and we want to do what we can for you because of what you've experienced, as Courtney said, the law is just we're looking at the vehicle, what's going on with the vehicle. It's all about the car.
There is no, pain and suffering or compensatory damages like that in the states that we practice in. So while that information is definitely important and we completely understand how disruptive it is to our clients' lives, what they're looking at are the repair orders, the visits to the dealership, and things of that nature, and the severity of the defect when assessing what your damages should be. Similarly, so other delay tactics that customer care can use that clients really need to be aware of is the amount of time spent spinning their wheels. They can miss certain deadlines for notifying the manufacturer under Lemon Law. So while they are kind of keeping you on the hook, telling you, oh, it's being reviewed or we're escalating it or things of that nature, you have to be very aware that if your state, like Georgia, for example, requires that you send notice via certified mail return receipt requested to the manufacturer, notifying them of your potential Lemon Law claim and giving them a final repair attempt. If you do that via phone or you do it over customer care, that doesn't count. And if you miss that 2-year, 24,000-mile deadline because you're busy in this minutia with customer care, that can really hurt your case. So it's important not to spend too much time spinning your wheels because in the end, it can be a huge detriment to you.
That's another common occurrence that I see a lot is where clients are saying, well, why did they get a final repair attempt? I already gave them a chance when I was talking to customer service to have their inspector come out. Well, by not doing it through the proper requirements under your state's Lemon Law, that doesn't qualify for a final repair attempt in a lot of situations. So as Emma was saying, that in Georgia, you have to do specific requirements to notify them and give them the opportunity for a final repair attempt. So realistically, you may think you've already done what is required under Lemon Law, but you actually haven't done it yet because you didn't do the proper steps.
Right. The only time I've been able to use a customer care phone call for a case as evidence was when basically a client was calling a dealership trying to get in for a visit and they were saying, the parts aren't available or something of the like. And so they called into customer care to report that, right? So we didn't have any documentation from the dealer that they were calling and trying to get in, but we had documentation because all customer care calls are documented and recorded that they called in, the part was unavailable, and that they had to wait. So for proof of visits or proof of, attempts to return to a dealership, those can be really helpful, but they don't hit the marker or requirements that you need statutorily for being able to show, hey, I gave them the proper notice under Georgia Lemon Law or Ohio Lemon Law, Maryland, whatever the case may be. There are very specific rules for that either you hit or you don't hit. There is no gray area. There are no exceptions of, oh, well, you talked to a supervisor, you told them they should have done what they needed to do. No, it doesn't work like that. The onus is on the consumer, not the manufacturer in those situations. Similarly, so the onus is again on the consumer when it comes to documenting these repair visits to the dealership. So dealerships can often play a part in these sort of delay tactics in preventing a consumer from bringing a claim by either, not documenting these visits because they couldn't duplicate the problem, right? How many times have you heard that? Well, I didn't get a repair order because no work was performed, and that's inaccurate, right? Or they told me my problem was normal, so I just haven't gone back again, right? These are all sort of tactics too that the dealerships can engage in that again will prevent a consumer from being able to get the necessary visits that they need or take the next steps that are required to pursue a Lemon Law claim.
Yeah, that's something we run into all the time. Just this morning, I was talking to a client. We don't have a repair invoice since September, so 8 months ago. And I said, "Can I assume the vehicle's been okay since then?" And he said, "No, it keeps stalling on the side of the road. It keeps turning off on me." And I said, "Well, have you been back to the dealership?" And he said, "Yeah, they're not doing anything, so they don't give me any sort of repair invoice, and they're not fixing anything. They can't find anything." So that's completely incorrect, improper. If you are going to the dealership has to give you a repair invoice, because it's crucial. It's crucial to these cases that we have those repair invoices. Just your word that you were there, unfortunately, is not good enough. It doesn't do much for us under the law. We need those repair invoices. And I don't always think it's purposeful on the part of the dealership in not giving a repair invoice or trying to delay anything. I don't always think it's some sort of grand conspiracy, which sometimes a client might think, or it might seem like if you're the one who's dealing with it. I think sometimes the dealership is just like, do you really need it? What's the importance of it? Because they're not lemon law attorneys. They don't know. So it's always very important for our clients to understand, yes, you need those invoices. Make sure you're getting them. Make sure everything is being documented.
And if you're having a situation too where the dealership's saying, we don't want to see your vehicle anymore, what I often will tell clients is just because one dealership is being stubborn and not being helpful or compliant, there are other dealerships. So if there's one that's nearby or not too far from where you originally were going, I say go there and they can look at the vehicle just to document that you are taking it in if the first dealership is not being compliant.
Right. You have some responsibility in this. Actually, you have a quite heavy responsibility as a consumer. You can't just sit back and say, oh, well, they wouldn't take my vehicle, or it keeps, failing on the side of the road, like your example, but I just keep having them jumpstart it, right? Because I got to get where I'm going, which is understandable. I don't want this to sound like we're saying that we don't understand the effect it can have on your life. We're just saying that the responsibility does fall on the consumer to be their own advocate, right? And to push the claim forward. And that example I gave, so I've had many cases where a vehicle fails to start, right? But AAA comes, jumps it, they bring it to the dealer, and it starts up just fine. They can't find any problems. Whereas we always recommend, no, just have it, leave it, have it flatbedded to the dealership in its current state so that they can try to diagnose it. But I understand that that's a huge difference, right? If you have it jumped, you can get to work and go to the dealer later. But if you have to tow it right then and there, it interrupts your entire day. But the tough part is it's sort of like, well, do you want to be able to show them that there's a problem here? Or do you want to have to keep going with this defective vehicle? Something more needs to be done. Some action on your end needs to happen. You can't just sit back and say, well, I have a video of it happening. While that's helpful, it's just not enough. You have to press it forward. Additionally, we often have dealerships that tell clients that they can't duplicate the problem, or the problem that they're experiencing is normal. That one's also tricky too, right? Because you only have so much control over what the dealership does or how well they diagnose the problem. So it's really tricky sometimes to get around that. So what we usually recommend is like what Steven said, right? Try a different dealership, see if maybe they can, look into it deeper. Go on a test drive with a technician, or video the problems, right? While videoing isn't a perfect system, it at least gives us something to bring into court or wherever we have to go to prove the claim, other than just, like you said, your word versus theirs, because that's a really tricky situation to be in.
Yeah, I always tell clients, help the dealer help you. Take the videos, take the pictures, offer to go on test drives with them. Do anything you can to have the dealership verify your problem, because if they verify your problem, your case is infinitely better. If you absolutely can't get them to do it, and you've tried other dealerships as well, it still is helpful to have the repair invoices, even if it's saying cannot duplicate. It's always best to have the ones where the problem's being verified. But if we can't have that, I'd at least rather have a repair invoice where a problem's not verified than not have a repair invoice at all. And then, like Emma was saying, we can also use the photos and the videos. It's not perfect, but it's certainly better than nothing. So do everything you can to get it verified. And short of that, do anything you can to prove that the issue really is there. That's something that becomes infinitely helpful to us.
Another thing that I've seen that is helpful as well, if you're showing them a video at the dealership, but it's not happening when they're looking at it, make sure that they note down they saw the video, because I have had repair invoices where they note, we saw the video, we saw the issue in the video, but we were not able to duplicate. At least they are acknowledging, hey, they did see something in your video, and they're writing down documentation to show, all right, you did show it to them, but they weren't able to be successful in identifying the issue.
Right. And I had that before. I had my own Lemon Law claim, I don't know, probably 6 years ago at this point. And I ran into the same issues, right? I was like, I don't know, a good 6 months pregnant. And when I was driving my vehicle, the odometer would go to 0 and every single light would start flashing on the dash, right? And all the messages were coming up: ABS system failing, transmission system failing. I would bring it into the dealer. We'd shut it off. And once they turned it back on, it was running fine. I probably had at least 4 visits where I had to bring it back and they kept telling me everything was normal. Being a Lemon Law attorney, I took videos, I took photos, I showed it to the dealer, and I got the same response that our clients get, right? Unless it happens here, there's nothing we can do about it. So finally, literally, I think my 3rd or 4th trip, I go to pick it up. The dealership where I would get it from, they have you kind of come into this giant bay where they have all the trucks or all the vehicles ready to be started and moved out. And I got in, started the vehicle, and it happened immediately. And I just grabbed whatever nearest person from the dealership there was and just said, it's happening. Okay. Can you finally do something about this? Will you finally believe me? From there, then becomes this series of multiple parts being replaced, having to ask Honda for approval to replace the parts. Because that's another thing we run into too, right? The part that they wanted to replace that they weren't totally sure was causing the problem, I guess it was the instrument cluster that was in the dash, was a $3,000 part. So they had to go through asking Honda for permission to replace that part before they could actually, attempt to repair it or fix it, which is also frustrating in and of itself, right? These warranty terms and conditions, while they are, generally pretty flexible in terms of, hey, it just has to arise during this time, there are troubleshooting and different requirements that manufacturers have before a part can be replaced, right? How many times we've heard clients say, why won't they just replace my transmission? They keep doing a software update, or they're only replacing this part and that part, right? As opposed to just replacing the whole thing. Well, these warranties, in order for the dealers to get paid for their work, right, they have to go through certain steps before they can get there, which is also a super frustrating process.
So I've also had issues where lack of communication with the dealership when they have your vehicle in their possession about a part is a problem, because sometimes the dealership will say, oh, the part's not in yet, and then the client will not contact them for a while. And at a certain point, the part will come in. The dealership won't go out of their way and say, oh, you know what, the part's in. I've had to have clients, I'm like, call, make sure, just follow up with them, because all of a sudden they'll be like, oh yeah, we do have the part. But had our client not called, we would have not known that. So sometimes you got to just be persistent in following up with the dealership when they are addressing your vehicle.
Absolutely. I always tell clients to call once a week if you're waiting on a part or if your vehicle is sitting at the dealership. If you're waiting on anything from the dealership, whether it's just a call for a part or a call to let you know that your vehicle's ready, always follow up with them, because I have seen it so many times where either the part comes in or even the vehicle is ready for repair and no one calls the client. A few months ago, I had a client got angry. They were angry with the dealership. They were angry with the situation. And they said some sort of offhanded comment to someone at the dealership that was, I don't even want this vehicle back. The dealership then took that to mean, okay, well, once it's repaired, we're not even going to call them to let them know because they don't want it back. About 9 months went by, and I finally got through to the client that you need to call the dealership and see what's going on. And lo and behold, the vehicle had been sitting there ready and fixed and repaired for months, but they never called the client because someone said, oh, they said they didn't want to be called because they didn't want the vehicle back. So always make sure you're following up with the client, because that became a whole disaster because the manufacturer was saying, well, they're not going to be credited for that time out of service because the vehicle was ready. They just refused to go pick it up. And in our client's eyes, they thought, well, no, I would have picked it up if I hadn't known it was ready. That was just an offhanded comment that I made out of frustration. So always follow up with the dealership is the bottom line.
We run into those same sort of ships passing in the night sort of scenarios here at RLG too. A good example I can give is a Maryland Jaguar case. The client had been back multiple times for a warning light that kept coming up on his dash. And he was like, it just came up again. Should I go back in? And obviously our answer is always yes. But where it got tricky was we had just sent out the final repair notice under Maryland Lemon Law. So he was like, I don't want to have to go back twice. So how about we wait until they say, hey, we've received your letter. Let's bring this in for service before I bring it back again. And we agreed on that, right? Because it wasn't a defect, it just something that would arise. The light would come on and then it would go away and he could keep driving. So I was like, okay, I understand. I get that it's a huge impediment to your life. They should be getting the notice soon anyway. So we'll just hang tight. So lo and behold, the message keeps coming up more frequently. So he just has to take it back. He has to take it back. I checked the tracking for the FRA. It said it landed, let's just say, February 18th, right? And at this point, we're at March 7th. So I reach out to Jaguar and say, hey, I know that this letter landed with you. You received our final repair, attempt request. The client's bringing it back to the dealer. I need somebody to communicate with me so that we can get this to count towards the FRA. Jaguar responded saying, hey, I don't see that we ever received this letter. And I responded with the tracking, the notice, and again, telling them the vehicle's going back in again. So you need to do something about this. I get crickets, no response. To be proactive on our end, we also resent the FRA just to be on the safe side because they were saying they didn't receive it, even though we clearly had tracking confirming delivery. So we send it out again. Client goes back to the dealer. Jaguar finally, a different rep, reaches out and says, hey, Emma, we have your letter. We want to do our FRA. And I was like, well, the vehicle's at the dealer. It was like ships passing in the night, right? They contacted us on like March 21st. The vehicle was ready from the repair at the dealer on March 20th. So it was like, well, the dealer, the car's already ready. Here's the repair order. Can this count as your final repair attempt? Because we notified you. I followed up with you, even though technically I didn't really have to. But I wanted to make sure that this counted. And Jaguar was basically like, well, no, because we didn't know and we weren't given notice. And so we want, because in Maryland, you have 30 days from receipt of that letter to repair the vehicle. So that would have tacked on an additional 30 days when we already were past the original 30 onto the client's case where we had to sit and wait and see if the problem came back again in order for them to do the FRA and then move forward with Lemon Law. Because if the problem was fixed after that visit on March 21st, we wouldn't have another FRA to notify them for to be able to push for the repurchase. It kind of cuts the case off at the knees. So lo and behold, where that kind of landed is at this point where the client's driving the vehicle for a bit to see if the problem comes back again. If it doesn't, he's good with settling for cash as opposed to pushing for the repurchase because he kind of understands the whole scenario. But that's a good example of, ships passing in the night. And if this was just a consumer, right, that was doing this on their end without that line to Jaguar that we have to notify them and at least, be able to have that line of communication, they're kind of stuck spinning their wheels on the other end. And then the FRA is up. They've got, you know what I mean? And there's nothing more they can do. And technically they didn't fulfill the requirements under Maryland Lemon Law, or, that would be up to a judge to decide whether they did or didn't.
I think one of the most common things overall is miscommunication when a client is trying to address this on their own prior to coming to us. Oftentimes, whether it's the dealership or the manufacturer, statements will be made, whether on the phone or email through customer service, for example, where they're saying, oh, well, I received your demand for a repurchase or a buyback. It's being reviewed. I'm, processing your demand. And clients will simply sometimes hear, and it's easy to misunderstand sometimes the way they phrase these emails. Oh, well, they're going to buy back my vehicle. It's being processed. My request is being processed. Then after months and months of not getting any response, they'll come to us, and when we get an initial offer and it's not repurchased, they're like, well, wait, what's happening here? Because they were processing my repurchase request. Well, what they're doing is they're reviewing it. They're not saying, oh, yes, you asked for it. We're going to give it to you right away. So you have to understand what is really being said in these communications with either the dealership or the manufacturer, because it's not always straightforward what you think. There's actually more going on. Another example, and Emma, you might remember this one from a couple months ago. A client came to us after dealing with customer service. And he said, well, they promised me all my monthly payments back. And what they really had said was monthly payments for when your vehicle was out of service, not every single payment. So theoretically, we're looking at, let's say, a month and a half your vehicle was out of service. They were talking about just that time, not the entire 10 payments that you made during that time, because otherwise they would just buy back your vehicle. Why would they reimburse you all your monthly payments but not repurchase your vehicle? So you got to understand what they're telling you when you are discussing things with them.
Yeah, I do remember that. And I think where we landed kind of with the client was, okay, maybe she said that she was going to try to get all your payments back, right? Because it's kind of difficult, right, to tell a client or consumer that maybe they misheard or that they misunderstood something. They can be pretty adamant that this is what was said to me. So it can sometimes be, a delicate balance. But what it came down to was that wasn't in writing, right? There was no proof of that. So we had to work with what we currently had. I had a similar situation too, where the client had said that when he had previously talked with customer care, because what happened was, so he got the buyback offer through the BBB, or he had started the BBB process at the same time that we submitted our Lemon Law notice. So there's like a separate division that reached out to us to say, hey, we're going to buy this vehicle back. Let's close out this BBB claim and we're going to handle it moving forward. And he had claimed that same representative had told him, hey, if we buy your vehicle back, we're also going to give you all your insurance payments back, which aren't normal in Lemon Law, right? You don't usually get those back. So I had said to him, okay, do you have that in writing? Oh, yes, she emailed it to me. She told me she was going to get them back. And I was like, all right, well, dig up that email, send it over to me. I will forward it to her and say, hey, you promised this. You need to, give this to our client. Lo and behold, that email couldn't be found. Right. And it just sort of ended up being a situation where maybe that was said over the phone, or maybe it was something that was discussed, but nothing that was solid. And the client just misunderstood. So it does get really tricky. And that's why it is so advantageous to have a lawyer, because we're used to this stuff, right? We know what's normal. We know what they usually offer. So when a client is telling us something that doesn't sound quite right, we are usually correct in saying they probably said this, right? They probably were saying that they were going, like Steven said, they're going to review it or they're processing it. Not that it's actually going to happen because, you don't qualify for lemon law, right? Or, some other reason why a lemon law repurchase just wouldn't happen. These miscommunications are huge, and they can be really difficult to navigate as an attorney, because it's a delicate balance between respecting what your client says and trusting them, because we do, but also kind of breaking it to them that, hey, that's not quite what happened. Or if that is what happened, we don't have any proof of it. So we have to go with what we have right now, which is X, which can be tricky as well.
One thing I would say is, once you start this process, if you start on your own, make a file. If you get any emails from the customer service, save those emails. Whether it seems insignificant or not, keep those emails, because there is another situation where Em and I were dealing with a client in Colorado where, prior to us getting involved, they emailed and said, we will reimburse you all your rental fees. That was a very helpful email, even though we had to kind of drag it out with the manufacturer to say, you promised this prior to us being involved. We need this and additional sums to get this resolved. So that email did come very handy. But these emails, keep a file. Just keep a file, save them, and then later on we can help you say, well, this doesn't really help, but this is actually very helpful. So don't just disregard, lose your temper, and delete those emails when you get frustrated. It might happen. It's very easy to say, forget it. Why am I even keeping these emails? Keep them. You don't know when they will be handy.
Or even just to confirm the conversation, right? I've had clients say the service manager told me that he duplicated my problem, or the service manager told me that they've seen this before, or customer care said this. So what I usually recommend is then just pop off an email to them saying, hey, just wanted to confirm our conversation wherein you stated X, and just have them write back confirmed. Like, just something small like that can be so helpful, because yes, even that case was really tough. And that's another delay tactic that we're running into too, right? So what had happened there is the client was in a rental, right? And the manufacturer agreed to reimburse them the cost of that rental once the repair was completed. So that can be really tricky too, right? Because as the case is progressing, if the vehicle is not fixed yet or the repair is not completed yet, the client is still waiting for this rental reimbursement from customer care, right? And we get nervous about getting involved prior to that reimbursement, because we've definitely had it before where, like we said, it's two separate entities. No, I should say that. Like we said before, it's two separate groups within the manufacturer, or it can be a law firm outside of the manufacturer that's handling the case, right? Other than customer care. So you have customer care that's one group, and then you have either the internal arbitration group that we deal with or an outside law firm. They're not necessarily going to respect or abide by what customer care told you, right? So there are some manufacturers that we know will, but there are others that we know if you have outstanding rental charges, right? And you have not gotten that check yet, and then we step in and get involved, customer care is going to cut off communication and they're not going to send you that check. So I've had cases where we've just had to, like, the client's been signed, we've retained them, but we have advised them, listen, we are going to wait to send this letter to the manufacturer to make sure you get your money first. And again, it depends on how much the rental charges are, right? If it's like $500 that they're waiting on, sometimes it's worth risking if it's taking too long. But I've had it where it's like $7,000 worth of rentals that these clients are waiting on that we don't want to disrupt that process. But then at the same time, they have a vehicle sitting out of service waiting for repair, and they're kind of stuck in this limbo that, again, can delay the case. But again, you have to kind of balance the scales when it comes to that in terms of what is best for the consumer.
Yeah, I see that all the time. And that's a situation where a lot of times I'll even leave it up to the client. I'll say, look, we can do it now, but understand that you might be risking the rental reimbursement, or we can wait. But it's never a situation where I would want a client to come back and say, well, whoa, you didn't tell me that I might be risking the rental reimbursement, or you didn't tell me that it might be delaying things. So that's a situation where we would always leave it in your hands and we would ask you what you want to do, giving you all of the facts.
Yeah, we have a case manager now for a specific manufacturer who shall not be named, who is so notorious for doing that every single case from them that comes through, she has to check first, do you have outstanding rental fees before we move it to case accepted for us to submit our letter? Because they don't often tell us, right, during the intake process. And then that letter goes out. And it's not something that can't be undone, right? We have had it before where it's sort of ships passing in the night, right? We sent that letter out. Then, lo and behold, we found out that those rental charges were outstanding. We usually just withdraw our representation. The client gets the money, and then we just start it again. So there are ways that we could unwind that. But again, it's delays, right? It's more time that most of our consumers don't want to spend waiting, because then that's even before we get to the review process. That's before we even get to the evaluation or negotiating settlement or anything like that, that just keeps the process from, dragging on and on. But again, I think this all kind of circles back to that's why it's so important to have an attorney when you're experiencing these delay tactics, right? Don't let it go for too long. If you don't feel like customer care is listening to you, if you don't feel as if you're being heard or that you're getting anywhere with them, don't wait 6 months before you call a Lemon Law firm for assistance, right? Because you can always call our intake line for a free consultation and say, hey, they're going to give me an answer on Friday, so I'm just going to wait and see what they say. But I wanted to know, do I have a case with you if they say something that I don't want to hear, right? We have a free consultation. Our intake line is always here at 833-4CAR-LAW for you to be able to at least get the process started and initiated in the event that they don't come back with the results that you are expecting or the results that you want. And then that way you're all set up, you're ready to go. You know you have representation if you need it, and there are no further delays when moving the action forward. And this is all, again, stuff that happens even before we even get to getting repurchase offers, getting settlement offers, and having to analyze those and whether they're valid. So that's why it's so important to have a Lemon Law attorney, because from day 1 to day 100, there's so many different moving parts that are involved that you need to have somebody who's experienced to be able to help you navigate that, because mistakes can be made along the way that can't always be rectified. So with that, we want to thank you for listening today, and we hope to see you again soon.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary, as outcomes are determined on a case-by-case basis.